Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London, and this morning I'm looking at a book which has come to us from Oxford University Press. This book is an interesting one in the Chancery jurisdiction. It's trusts law basically, and it's an area which the author found was an area which hadn't really had much commentary in the past, so he's produced this work and he asked us to review the book, and I'm delighted to do so because it's a first-class work. It comes to us from Oxford University Press, and the title is The Supervisory Jurisdiction over Trust Administration. The author, of course, is Daniel Clarry, who will be known to many of you because of his work with the annual United Kingdom Supreme Court Digest. In other words, the annual report for the work of the Supreme Court. A very experienced man and knows exactly what he's doing. Now, Elizabeth and I discussed the book. She was the lead writer, and our title for our review is Fresh Research and Contemporary Perspectives on Trust Administration. And that's what you get with the book. Very much the house style of OUP. Let's have a look at it. It's only a small book. Hardback, you can hear that. There we go, there's the front. Then there's the spine. There's nothing on the back. You can see the spine. And now the book itself, it runs to 300 odd pages. The index at the back, it's just over 300 pages. The index at the back is by paragraph numbering. As I say, this is the house style of OUP, and it normally shows right at the beginning. There we go, you've got the structure there. And then what you've got is the last chapter, this conclusion, chapter 10. You see the paragraph numbering there. That's how you find what you're looking for. A lot of footnoting, of course, as usual. But you can read through the text without looking at the footnotes, which I do find helpful because the footnotes can be a menace sometimes. You want to read the basic detail of the book itself. There's the front page. Mind you, I say that it's a nuisance for footnotes, but footnotes do have a very important role to play if you're doing research. So please accept my apologies if you are upset by that remark. There's the detail from OUP, and then there's a very nice dedication which Daniel has put in, which I should just show you there, which you can have a look at. And then we get to the book itself. You know, the people who work on this book, these books, do a lot of work, and a lot of people are involved, so I like to do the mention who it's dedicated to. Lord Walker has produced a very useful foreword, which is well worth reading. Robert Walker's statement is very good. The book as a whole will deserve a place on the shelves of both practitioners and academics, and I have no hesitation in commending it. Thank you, Lord Robert Walker. Then the preface comes from Daniel himself, setting out where the book came from, and I've already alluded to that. And then we get the contents of the book itself. And then it's the introduction, history, and so forth, remedies, conclusion at the back. 10 chapters in total. Then you've got some tables of cases from the UK and other places as well, different, basically Commonwealth jurisdictions. Isle of Man, Jersey. So you've got quite an interesting range, and a couple from the States. Table of legislation. There again, that's international instruments. Then we look by country at the legislation. Again, that covers quite a large area. Part 1, the introduction. It's split into parts. You've got a little mini index for each chapter, which is quite helpful depending on what you're looking for. And as I say, you can see you've got footnoting and you've got the paragraph numbering at the side. And as I say, I thought this was a very useful book in the law of trusts, which I think will be relevant to quite a large number of people in that specific area of law. So lawyers, counsel especially, embroiled in the vicissitudes of trust administration, we think will welcome the publication of this new and certainly erudite legal text from Dr. Daniel Clarry, published recently by OUP. Book is a tour de force of scholarship and insightful analysis of a particular aspect of the administration of trusts that has, oddly enough, remained underreported, you might say, or at least not extensively or formally commented upon for over 100 years at least. If this sounds curiously odd or oddly curious, it is, which is what the main mission statement is, because it appears, says Dr. Clarry, that no one has really tackled the administrative jurisdiction of the court over trusts in modern times, even though it's a matter of day-to-day practice in the courts, variation in other words. adding that one is hard-pressed to find any systematic account of the underlying jurisdiction itself. And he also refers to the various ways in which the court acts to facilitate the performance of trusts as constituent parts of a coherent whole, herein named the supervisory jurisdiction over trusts administration, and so forth. And it appears that practitioners advising on trusts and therefore seeking advice from the courts is an occurrence that is so commonplace and routine that it is perhaps overlooked as a topic crying out from extensive and detailed research, which this book certainly provides. And as I said, you can see in it already, it is actually very detailed and a tribute to the scholarship that Daniel has put into this. The extent and the depth of the said research is worth commenting upon, however briefly, as much as if it had been carried out under the auspices of or within the precincts of some of the world's foremost academic institutions, such as Cambridge University and the Max Planck Institute for Comparative and International Private Law. Clarry has also been awarded fellowships at Harvard Law School and the LSE to give it its full title, which supports the publication of this book and related research. The core principle, of course, around which the book is organised is that it's that of performance, supported by in-depth analysis, basically, of how the court in its supervisory capacity acts in various ways to facilitate the performance of trusts in modern times. And to conclude, I think it's fair to say, therefore, that the book offers a refreshingly modern perspective on a hitherto largely under-researched area of law, which trust practitioners will find both thought-provoking and useful, particularly the commentaries on trust law, public law and private law. It's a distinguished monograph that will certainly pique the interests of academics as well as practitioners tasked, for example, with advising private clients, and we certainly commend it to you. Thank you very much, Daniel and OUP, for publishing it. The date of publication is cited at the 26th of December 2018. Let's just have one last look at it. There's the front spine, there's nothing on the back. Just opening it in the middle. Just looking, regulating the office of a trustee. Again, I think if you're a trustee, this book would be quite useful for you, because it says here the office of trustee is a central administrative cog that exists above and beyond any person who assumes that office. And of course that's fundamentally correct. That's chapter 5. You see the paragraph numbering, you see the actual footnoting. Again, it's an important book in different levels. There's the academic level, but there's the practitioner level too. A big thank you anyway to Dr. Clarry and of course to OUP and all the people who've been involved in the production of the book. Thank you very much indeed. Do look at our reviews on the webs and in the journals. Thank you. Bye-bye.